In the last lectures, we have seen the differences and similarities between the trusts and other legal concepts. We have seen that trust is an obligation annexed to the property and arising out of the confidence reposed for the benefit of another person. Today, in this lecture, we will see the classifications of trust. The manner in which a trust arises is the most significant standpoint from which trust may be classified. It is also usual to divide the trust into various kinds depending on their special characteristics. Now if we move to other slide here. These are the classifications of trusts: private trust and public trust, executed and executory trust, fixed trust and discretionary trust, bare or simple trust or special trust, express trust, formal or implied trust, resulting trust, constructive trust. The first one, we have seen the differences and similarities in between private trust and public trust. Further here, when you study this private trust and public trust, again we will see in the charitable trust. But for the purpose of classification, we can say like this: a trust may be a private trust or a public trust. The criterion for deciding whether a particular trust is or is not a private trust is whether the said trust is or is not for the benefit of individuals. It is the extensiveness of objects which affords some indication of the public nature of the trust. The test is whether it is for a large and extensive section of the community. In a private trust, the beneficiaries are defined and ascertained individuals, or who within a definite time can be definitely ascertained, while in the latter, beneficial interest rests in an uncertain and fluctuating body of persons, either the public at large or some considerable portion of it answering a particular description. If the author of the trust divests himself of any interest for himself or for members of his family in property over which trust is created, he does not thereby make the trust a public trust. When the object of the trust is to preserve worship of settler's own deity and image of his religious preceptors, and when there is no provision in the deed by which the members of public have any right to worship in the temple, merely because there is a provision for the feeding of poor incidental to the puja of deity, it does not make it as a public trust. where a trust is created primarily for the benefit of members of the settlers' family, it is a private trust and not a public trust. There is a well-known case in India, reported All India Report 1981 SC page number 798, Radhakanda Deb versus Commissioner of Hindu Religious Endowment, Orissa. The Supreme Court had outlined the following guidelines to determine an endowment, whether it is a public or private. Now in this one, we are going to see the guidelines to determine an endowment, whether it is a private or public. And thereafter we will see the guidelines for the purpose to identify the trust is public or private. First of all, we will see here whether this endowment is public or private. The first one, when the origin of the temple cannot be ascertained, the question to be decided is whether the member of the public can use the temple as of right or not. Second one, the fact that the control and the management of the temple rest either in a large number of persons or in the member of the public, and the founder does not retain the control of the management of the trust is a circumstance to show that trust is public. Now from this one, what we have studied here, the control and the management of the temple is vested in the large number of people or the members of the public, then it is a public trust. And also, founder does not retain the control of the management of the trust, then it shows that it is a public trust. And third one we will see here, when the document is available to prove the nature and the origin of the endowment, and recitals of the document show the control and the management of the temple is retained with the founder or his descendants, and the expensive properties dedicated for its purpose or the maintenance of temple belongs to the founder himself, then endowment is private in nature. Finally, when the evidence shows that the founder of the endowment did not make stipulation for offering or contributions to be made by the members of the public to the temple, it would be an intrinsic circumstance to indicate the private nature of the trust. Now we will see the test to determine whether the trust is public or private. Then we will see the guidelines here. The Supreme Court has given the guidelines. First test given, these are the tests given. The first requirement of a public trust is that it must be for the benefit of community or a class of community as distinguished from private individuals or fluctuating body of private individuals who are ascertainable persons or are capable of being ascertained. Second test, there must be definite expression of intention to divest and evidence of actual divestment of the right, title and interest of the donor in the property in favor of charity and of the same to have become vested in the trust. Third test. The fact of the divesting can be proved either by written document or by other evidence, since it is not necessary that there must be anything or any writing to constitute a valid dedication. Fourth test, the origin of the temple that we have seen already in the endowment also, the origin of the temple, the manner in which its affairs are managed, the nature and extent of the gift received by it, and awareness of the management and the beneficiaries that trust is for the benefit of public are important factor to be considered. Fifth test, whether the exercise of the right by the people in enjoying the benefit is as of right or is by way of concession allowed. Sixth test, whether the scheme envisages association of the members of the public at large in the management of the trust. Seventh test, where the document proving the origin of the endowment shows that the control and the management of the trust vested with the founder or his descendants, and expensive properties are dedicated for the maintenance of the trust belonging to the founder, the facts in themselves would be conclusive to show the private nature of the trust. Eighth one, the evidence of the lack of any stipulation by founder of the offerings or contributions to be made by the members of the public is an important and intrinsic circumstances indicating the private nature of the endowment. Mere fact, that's very important, mere fact that public is freely admitted to the temple does not mean that court should readily infer therefrom dedication to the public. It is necessary further to establish if the user is as of right. That's an important classification in between the private trust and public trust. When you say private trust, what we have seen, when you summarize what we have seen now, when you say private trust, it is for the benefit of certain number of individuals, including founder or author of the trust or his descendant, then it must be a private trust. If the trust for the benefit of general public at large, or sometimes it may be a section of the general public, then it is a public trust. In addition to that, we have seen the control and the management of the temple. Who is controlling and managing the temple? That's very important. How they are managing the affairs of the temple? That's very important. And we have seen the origin of the endowment, how it is given, how it is started, that we must consider. And the contribution. Who has made a contribution? Who has made offerings? That's very important. And the people or the public may go to the temple. It doesn't mean that it is a public temple. That also we have seen. And further we have seen the interest, the expression of intention to divest and evidence of actual divestment of the right, in title and interest of the donor in the property to the public. That we must consider. And the written document, if there's a written document, then we must see the written document, whether it constitutes a valid dedication. And we have seen finally that that's the thing we have seen up to now. Now we will see the second one, executor trust and executory trust. Executor trust, simply you can keep it in your mind, that's done perfectly. Executory trust is something to be done, something to be fulfilled, then it is known as executor. An executor trust is one in which the testator or the settlor or the author himself marks out the beneficial interest. He is his own conveyancer. He is the one who is convey the property to himself. In an executory trust, the execution of some further instrument is required in order to define the beneficial interest with precision. It does not mean that the property is not subject to a valid trust immediately, but that it remains executory until further instrument is duly executed. The importance of this distinction lies mainly in the application of rules of the construction. In the case of an executor trust, the rules are applied strictly, while in the case of executory trust, they are construed more liberally, because some more document to be executed. The court will attach less weight to the language used by the author of the trust and will try to discover his true intention so that the final deed reflects and gives effect to the intention. In the words of well-known English author Underhill, in the construction of executory trust, the court is not confined to the language used, where such language is improper or informal or would create an illegal trust, or one which it is impossible to execute, or would otherwise defeat the settler's intention as gathered from the motive which led to the settlement and from its general objects and purposes, or from other instrument to which it refers, or from any circumstances which may have influenced settler's mind, the court will direct a settlement to be executed in such form as will best answer the intention of the parties. But in the case of executor trust, technical terms are construed in their legal and technical sense. Now we will move to the third one, fixed and discretionary trust. A fixed trust is the trust in which the beneficiaries have current fixed entitlement to such income as remains after proper exercise of the trustee's power. On the other hand, a discretionary trust is one in which the beneficiaries have no such current fixed entitlement, but only a hope that trustee, in carrying out their duty, to consider how much income might be paid to the beneficiaries, and will in their discretion pay that income to a particular beneficiary or beneficiaries. The beneficiaries have no interest in possession under the trust. The beneficiaries of the discretionary trust do not have concurrent interest in the income, nor do they have a group of interest. They all have individual rights and are in competition with each other, and what the trustees give to one is his alone. The reference to a class or group of objects under the discretionary trust is merely convenient form of reference to indicate individuals who satisfy the requirement to qualify as objects which may separately receive benefits under exercise of the discretion. There are various reasons why the settlor prefers to establish a discretionary trust rather than a fixed trust. Some of the important ones being to protect the beneficiary against creditors, to continue exercise control over young beneficiaries, to make adjustment according to the circumstances when a trust is set up. When a trust is set up, there is no way of knowing how the beneficiaries will fare in the future. Which of them will be most in need, which will be deserving. Trustee can make all these factors into the consideration in making their decision. The essential feature of a discretionary trust is that the property is conveyed to the trustee to be held by them on trust to apply the income or the capital or both for the benefit of beneficiaries in such proportions as the trustee shall, in their absolute discretion, think fit. It is necessary to specify the trust period, which should not exceed the perpetuity rule or perpetuity period. A discretionary trust may be exhaustive or non-exhaustive. It is exhaustive when the trustee must distribute the entire income, and non-exhaustive when the trustee has the power to deal with a part of the income. A discretionary trust is one which, when you summarize this one, a discretionary trust is one where the trust income and capital may be paid to one or more of a class of beneficiaries as trustees may think fit. This is a special kind of trust which is subdivided into fixed trust where the objects are identified, and discretionary trust where the choice is left to the trustee. And the fourth one here, bare trust or symbol trust and special trust. A distinction is sometimes made between bare and symbol trust on the one hand and the special trust on the other. Bare trust is the trust in which a trust is merely repository of the trust property with no active duties to perform. Where the beneficiaries becomes absolutely entitled against the trustees, as where the life of the tenant dies, and the remainderment becomes absolutely entitled, or whether a minor absolutely becomes a minor beneficiary becomes absolutely entitled to attaining majority. The bare trust is also arises when the settlor conveys the property to trustee without any declaration of the beneficial interest, or where the transfer is made by fraud or without intending a beneficial interest to pass. Now the bare trust, when you talk about bare trust, simply you can understand this is something given to another person to hold it, and at the end of the period or something that should be given to another person. You don't talk about any beneficial interest. You hold the property on trust. Once the trust is over, the property must be transferred. So it is clear that a simple trust is merely hold the property for the benefit of the sesticue trust, such as payment of gift by father of a girl to prospective husband or the prospective father-in-law. In a special trust, trustee has duty to perform as provided in the deed of trust or instruments of trust. However, a trust which was originally a special trust may become a simple trust. There's a possibility like that also. If a trust, for example, if a trust is created during the heir's lifetime to collect the rents and profits, and thereafter, and after the payment of costs of repairs and insurance, to pay the balance to A during his lifetime, and on his death, hold the property on trust for C. It will be a special trust. But if A dies, then the trustee becomes a bare trustee for conveyancing the legal title of the property to C. Because the property transferred to somebody to hold the property and give the beneficial interest to A during A's lifetime. If A dies immediately, then the property should be transferred to C. Then at that time, earlier he was a trustee of special trustee, he becomes a bare simple trustee, becomes a bare trustee just to keep the bare trustee in the sense just to keep the property and transfer, keep a property on trust and transfer it at the end of the period or some other things happen. Now the bare trust, when you summarize this one, bare trust is one where the trustee holds the trust property on trust for one or more beneficiaries. There are two kinds of bare trust. A single bare trust in which the trustee holds the property on trust for single beneficiary. A joint bare trust is one where the trustees hold the property on trust for more than one beneficiary. Bare trust is created where the trustees move. As soon as beneficiaries becomes major or is competent to hold the property, trustee transfer the legal title to the trust property to the beneficiary or beneficiaries and put the end to the trust. When the property transferred to him, the trust comes to the end. Express trust. An express trust is one which is intentionally declared by the author of the trust or creator of the trust. It is a trust which has been expressed either in writing or by word of mouth and does not include a trust which arises from the act of parties. A trust for a specific purpose is the same as an express trust. This is the first time the definition for the express trust is given in the Trust Ordinance. The Trust Amendment Act number 6 of the 2018 inserted the definition for the term of expression, express trust. What's the definition given here? The express trust means a trust that is created by author of the trust, generally in the form of instrument, in writing, with the certainty indicating the intention of the trust, but does not include constructive trust, does not include de facto trust, whether it is charitable or not. That's the purpose. Then when you see the first line here, a trust that is created by author of the trust, generally in the form of instrument. That's why we say the deed of trust. When you talk about express trust, there must be a deed of trust in writing. And also, it should indicate the intention of the author of the trust to create the trust, but does not include constructive trust. Because constructive trust arises by operation of law. De facto trust is declared by court in the absence of any qualifications that we will see later. Now we will move to other. Right here, an express trust. The express trust is one which is deliberately, that's the thing, with the intention to create the trust. That's why here, which is deliberately established and which the trust is deliberately accepts. Because in the case of constructive trust, it arises by operation of law. Even sometimes, trustee doesn't know that. He was under the impression that he was the owner of the property, but court declared that you are the trustee, you are not the owner of the property. That's why here we say, the express trust, trustee deliberately accepts. That's the thing under, for example, trust is created under section 5.1 and 5.2 of the Trusts Ordinance. Creation of trusts. Subject to the provisions of section 107, for the time being we don't talk about much here, we will see later. Simply you know that 107 is de facto trust. Forget about that for the time being, then we will see later. Then we start from the no trust in relation to the immovable property is valid unless declared by last will of the author of the trust or the trustee, or by a non-testamentary instrument in writing signed by author of the trust or trustee and notarially executed. Notarially executed. I highlighted those areas in writing and notarially executed. Before we go into that highlighted part, we will see that if the trust is in relation to the immovable property, then you must talk about section 5.1. You must see the section 5.1. No trustees in relation is valid unless declared by last will of the author of the trust. Then that is a testamentary instrument. Other one is by non-testamentary instrument. Then it may be a testamentary instrument or non-testamentary, doesn't matter. There must be a document in writing. And the author of the trust himself, he can declare that this property is a trust property. Or otherwise, he can execute a last will on the death of such person, it comes to the effect. It should be in writing and notarily executed. What is known as notarily executed? The term defined in the trust ordinance itself. When you see the section 3O of the trust ordinance, it defines as well to mean the instrument should be executed in the manner prescribed by section 2 of the Prevention of Frauds Ordinance. Prevention of Frauds Ordinance. Now the notarily executed in the sense it should be executed in accordance with section 2 of the Prevention of Frauds Ordinance. What is the section 2 of the PFO? That's a Prevention of Fraud Ordinance that is given here. No purchase, no sale or purchase or transfer of the land shall be of force or while in law unless the same shall be in writing. That should be done. It should be in writing and signed by parties making the same in the presence of licensed notary public and 2 or more witnesses present at the same time. Then the notary public should be there, parties should be there, witnesses should be there, then only you can execute the trust. Not only trust, even any document in relation to the land, the party should be there in the presence of the notary public plus 2 or more witnesses. And unless the execution of such writing, deed or instrument be duly attested by such notary public and witnesses. No trust in relation to the movable property. Now we have seen if the trust is in relation to the immovable property, that should be in terms of section 5.1. That should be executed in terms of section 5.1. Now, no trust in relation to the movable, but then it is section 5.2. It is in relation to the movable property is valid unless declared by last will of the author of the trust or of the trustees or non-testimony instrument in writing signed by author of the trust, or the ownership of the property is transferred to the trustee by delivery. Just say suppose there's a 3-wheeler or the taxi, car, cab service or whatever. Then I would like to create the trust in relation to the car. That's a car or 3-wheeler. Then just I hand over the property to another person just to give the key of the car to that person, then that is fine. No need to go for notarially executed document here because it is in relation to the movable property. If it is in relation to the movable property, then it must be declared by author of the trust, blah blah, non-testimony or non-testimony in writing signed by author of the trust, fine. Or just you can give the property, transfer the property to another person or trustee, that's enough. If it is in relation to the immovable property, then it should be executed, notarily executed. It should be writing, signed by author of the trust and executed, notarily executed. But in the case of movable property, just you can hand over the property, that's enough. Just you can hand over the property, that's enough. Or otherwise you can follow, it may be declared by author of the trust, by testimony or non-testimony instrument in writing, signed by author of the trust. Either way you can go. Then in this case, what happened in this case? Express trust may be constituted in one of the 2 ways. The trust may be effectual if the settlor transfers the property to a trustee for the purpose of settlement or declares that he himself holds it in trust for those purposes. This is another recent case. The court stated that Benedict versus Anthony case. In this case, what happened? The court stated clearly the section 5.1 of the trust ordinance especially annexed that trust created under chapter 2 of that ordinance, the trust ordinance must be notarily executed in the manner prescribed by section 2 of the trust ordinance. Now when you see further on this matter, when you see the English law, what they are mentioning, when you talk about the classification, we must see the English law first. The trust in the English law may be placed in 5 categories. First one, where there is a manifestation of an intention validly executed according to the formalities prescribed by law, that is known as express trust. That is, in Sri Lanka simply we can say 5.1. 5.1, maybe 5.2 also, because that also express trust. Second one, where though the intention to create the trust is not validly executed as above, it is enforced because of the equitable maxim that a statute may not be used as an instrument of fraud. That is one of the maxims that we have seen. That is known as informal trust. That is 5.3 that we will see a little later now. The third one, where a person transfers the property under the circumstances which raise an inference that he does not intend that the person taking or holding the property should have the beneficial interest, which results to the transferor or his legal representative. That is known as resulting trust, because it is coming back as a beneficiary of the trust, because the beneficial interest should come back to the transferor, owner of the trust. Then the fourth one, where a trust is imposed by court regardless the intention of the parties on the grounds of justice and conscience, that is known as constructive trust under English law. Then finally the fifth one, where a statute enacts that certain relationship give rise to the trust, that is statutory trust. These categories are not exclusive and tend to overlap. That's a problem always. The dividing line between resulting trust, express trust and informal trust is not clear. And it is doubtful into what category some kind of trust fall. The common classification is between the trust arising by act of a party or express trust. And you can say it is under category 1. The trust arising by operational law, you can say category 3 and 4. Category 2 does not easily fit into this classification. Then come to Sri Lanka. In the trust ordinance, the chapter 2, that is the sections, those are the sections relevant to the here, but there are so many sections in chapter 2. But section 5 and section 6. For section 5 that we have seen how to create a trust. Section 6, there are some reasonable certainty that we will see later. And chapter 9, sections 82 to 96. And section 107, that's the thing I told you that's in relation to the de facto trust of the trust ordinance. Then section 107 of the trust ordinance govern the origins of the trusts. Then the chapter 1, chapter 9 and 107 govern the origins of the trust in the law of Sri Lanka. Section 5.1 and 5.2 prescribe the form in which a document of the trust must be executed, that we have seen. While section 5.3, that's very important, declares these rules do not apply. These rules do not apply where they would operate as to effectuate a fraud. The section 6 reproduces the English three certainties rule. Section 5.1 and 5.2 read with section 6 falls within a category of 1, that is express trust. Section 5.3 read with sections 5.1 and 5.2 and 6 also falls within a category of 2, that is known as informal trust. Then the first one, now we are comparing the English law and as well as Sri Lankan law. When you say the first one express trust, that should be under 5.1 and 5.2. 5.3 informal trusts. Then section 5.1, that's of informal trust. Chapter 9 is headed constructive trusts, but includes both resulting and constructive trusts. Because when you see English books, there is separate heading for constructive trust and separate heading for resulting trust. But in Sri Lanka, the heading given, chapter 9, constructive trust, it includes resulting trust. One point I think I would like to say here. In Muthamba versus Tyagaraja, Sansoni CJ said that the dividing line between express and constructive trusts in the sense in which it is used in the trusts ordinance in Sri Lanka is very thin, and some cases fall within both categories. Some cases do fall within both categories, but the assumption of Sansoni CJ, the LJM Hure said here, that not too clear distinction in English law between express trust and trust arising by operation of law is reproduced in chapters 2 and 9 respectively is questionable. Since the classification of the Sri Lanka law of trust by the use of terms such as expressed, resulting, constructive, etc. may lead to confusion. L.J. Hure says, we shall in this investigation mere refer the trust created under chapter 2 and those arising under chapter 9. Since section 5 is to be read with section 6, trusts created under chapter 2 would be those where there is an intention to create the trust, and such intention may be manifested in the form prescribed by section 5.1 and 5.2, or on the proof of fraud by parole evidence. A trust arising under chapter 9 must fall within one of the categories in sections 82 to 83, 83 to 98. 82 just a heading that we will see later on the constructive trust. We will study in detail. Section 83 would include cases where there is a specific intention not formally expressed to create a trust in favor of settler. An analysis of the classification of trust in Sri Lanka would not be complete without a consideration of effect of section 107 of the trust ordinance. That's the de facto trust. Under section 107, a trust may arise even in the absence of a written declaration of trust as recorded by section 5, or in the absence of valid legal conveyance to the trustee as recorded by section 6. And such a trust may be imposed on a person who never agreed to be a trustee. The type of trust which arises under Section 107 must be classified as a special category. Trust in Sri Lanka could be classified under three heads. Trust created under Chapter 2, trust arising under Chapter 9, third one, trust arising under Section 107. Now we will see this case. Now in this case what happened, this is one of the interesting case in relation to the property. What happened here, the executed A, the name of the person A, executed for the benefit mainly of his younger son B, what the Lord Wilberforce called as voluntary settlement, which included 6,000 ordinary shares of a company of which shares he was a registered owner, and another 1,000 ordinary shares which had been issued by but not yet allotted into the name of the trustee. Then he has decided, actually this is a executed A, executed for the benefit of B, this amount of things, but 6,000 ordinary shares already there, but 1,000 to be allotted later. On the same day, A executed in favor of the trustee of the settlement a transfer of 6,000 shares out of which he was registered owner. That's fine. Now he was the owner of 6,000 shares, then he executed in favor of the trustee settlement, but died before any allotment of 1,000 shares of the new issue had been made. In due course, 1,000 shares were allotted the executors of A's estate. That's the after death executors appointed. Now that should go to the executors. Then the 1,000 shares were allotted to executors of A's estate on a payment by, because they have to pay for this one. They paid that money in respect of all these 1,000 shares. The question is now at issue was whether the 1,000 newly allotted, it should be simple, allotted share either devolved under the will of A or form a part of trust fund. And settlement trustees were therefore entitled to call upon the executors of A to transfer them of these shares. Now the issue here is in relation to 1,000 shares of the company. At the time of death, those were not allotted to the deceased. But after death, it was done, allotted. Then the executors appointed by the court, they paid the money and took the control of that. Now the issue is, if that 1,000 shares constitute a part of the trust fund, then it should be given to the trustees. Otherwise, no. The issue is whether the trustees created. The Privy Council said that under Section 6 of the Trust Ordinance of Sri Lanka, for effective trust to be created, there must be either testamentary disposition or transfer the property to trustee. Now he has, the deceased, transferred 6,000 shares of the company, but not 1,000. 1,000 shares at the time of death, even it was not allocated, those were not allocated to him. Therefore, there is no testamentary disposition also. In that case, it was rejected. Now we will see the formal and implied trust. What we have seen in the implied trust may be said to arise where the intention of the settler to set up a trust is inferred from his words or action. That's a precatory words that we have seen, that we will see later. Next lecture, so something we will see the effect of precatory words. The implied trust in that sense are probably best regarded as expressed trust, in that the trust is expressed, albeit in ambiguous or uncertain language. Now what we have seen in section 5.1 and 5.2. Unless it is executed in that way, there is no trust. When you see section 5.1, now when you compare here 5.1 and 5.2 and 5.3, 5.1 reads, subject to the provisions of 107, no trust in relation to immoral property is valid unless declared. Then until otherwise there is a declaration in writing and signed by author of the trust, there can't be a trust at all. When you talk about that is in relation to the immovable property, when you come to the movable property, again it should be executed in writing and signed by author of the trust, or otherwise the property should be transferred to that person. That's the mandatory condition. But 5.3 says these rules do not apply. These rules means the rules referred to in section 5.1, the rules referred to in 5.3 do not apply. Where they means again 5.1 and 5.2 would operate as to effectuate a fraud. If it leads to the fraud, then those two sections will not apply. These rules mean those rules referred to in 5.1 and 5.2 do not apply. That's why implied trust. Now say suppose there's no declaration done in terms of there's a land, say suppose immovable property land. There's no declaration of trust in writing, but still it may create a trust. Suppose, to take an example like this one, one person, say suppose A, transfer his property to B for the benefit of C. But he said, A said, dear, I'm transferring this property. That's not your property. Right? This is not your property. You must hold up. You can hold the property, but for the benefit of C. All told. Just out of mouth he has said something. Now B may argue after some time, say suppose A died. Then B now say, no, there is no trust. This is an absolute transfer to me. There is no trust at all. Why is that? Now, when you see the deed of transfer, that is an absolute transfer, outright transfer, nothing at all, nothing specified in relation to trust. Then B may argue, or B argues, that it is the outright transfer. There is no trust at all. Then what is happening here? If the B's argument, if A intended to create a trust, it should have been done under 5.1. He didn't do that because he has no intention to create a trust. Now what is happening here? B, with the help of 5.1, committing a fraud. That's why what we are saying here, with the help of statutory provision, the transferee commits a fraud. That's why if there's an argument like that, then A or the legal representative of A get the help of 5.3 and create a trust. Prove the trust. Not the create a trust, prove the trust. Because these rules will not apply. These rules are A did not execute anything in terms of section 5.1. Does it matter? Take the necessary assistance from 5.3 and create a trust under 5.3. Then it is not a formal trust. It is not a express trust. It is implied trust. It is an informal trust. The formal trust or the express trust, that is 5.1. Here, these rules in the sense 5.1 and 5.2, because of the 5.1 and 5.2, they use that 5.1 and say that no, at that time A did not intend to transfer this one, intend to create a trust, just he transferred. Because if he had some intention to create the trust, he should have done it under 5.1. He didn't do that. Therefore, it is a absolute transfer. Then A, if he is alive, A, or otherwise legal representative of A, can prove that these rules do not apply because now B commits fraud. That's the way they can prove it. Resulting trust, that we will see later very clearly, but for the purpose of classification, just we will see the term resulting trust seems to be limited to 3 well-defined categories. First one, where a man purchases a property and has it conveyed or transferred into the name of another or the joint names of himself and another person, when the beneficial interest will nominally, as it is said, result to the man who put the purchase money. Then the secondly, where there is a voluntary conveyance or transfer into the name of another person or into joint name of the grantor and another person, where likewise there is a prima facie, there is a resulting trust for the grantor. Finally, where there is a transfer of property to another, the trusts. Where there is a transfer of property to another on trust, which leaves some or all of the equitable interest undisposed. Then these are the 3 ways resulting trust may arise. Now we have seen the classification of trust. This is just we identified what is known as express, mainly private and public trust, that you know, that we will study even later also in the case of charitable trust. Executed, executory, that's, you can remember those things. Fixed or discretionary, that you can remember. But express trust, constructive trust, charitable trust, those things we will study later. Now we will stop with this one, today's lecture. Thank you.